So on the question of the different fields of law in South Africa, um, it will depend on how the question is asked, right? So you can answer it in different ways, either maybe by drawing a structure where you show that we have the law on top, and then we have like two branches, and then we have international law, and then we have national law, and then national law in the context of South African law, right? And then from the national law, and then you can have two branches as well, where you indicate that we have substantive law and then we have procedural law, right? And then under substantive law, would then have public law, private law, and commercial law, right? And then public law is the one that consists of constitutional law, administrative law, criminal law, and the likes. And then under private law, we have fields of law like family law, law of persons, law of patrimony, intellectual property law, law of succession, law of contract, law of delict, and so on. And then on the other side of the table, where we have procedural law, that's where you would look at like your law of evidence, civil procedure, and criminal procedure, and so on. So you can answer that question in the form of a table, or you can just answer it in the way you also look at like the mark allocation. If it doesn't give you a lot of marks, you can just randomly list and be like constitutional law, administrative law, criminal law, family law. It doesn't matter how you do it, right? But then if it's a question that has a lot of marks, let's say 10, 12, 15, 20 marks, then you probably do a table where you have national law, and then you have two branches. Those branches will be substantive law and procedural law. And then under substantive law, you have your public law, private law, and commercial law. And then under public law, you have your constitutional law, administrative law, criminal law. And then under private law, you have your family law, law of persons, law of patrimony, property law, and so on. And then on the other side, where there is procedural law, you have your law of evidence, civil procedure, and criminal procedure. And then on the question of the sources of law as well. So just to not get you confused, by the sources of law, we mean the places where the law originates, or where the law can be found. So in South Africa, we have multiple sources of law. That will be your constitution, the legislation, also referred to as the statutes. You can also refer that to as the Acts of Parliament. And then you have President, which is the previous court decisions. You have your common law, you have your custom, you have your customary law, you have your works of modern authors, you have foreign law, and you have international law. So for the sources of law, we mean where the law originates, where the law can be found, where as a student, if you faced with a problem, or as a legal practitioner, if you're faced with a problem, where do you go to find the law? So we'd start with the Constitution as the supreme law of the land, and then we have legislation, which are the statutes or the acts of parliament. We have judicial president, which are the court decisions. We have common law, we have custom, we have customary law, we have the works of modern authors, we have foreign law, and we have international law. So those would be your sources of law in South Africa. And then on the first generation rights, according to the Bill of Rights, um, the first generation rights are also referred to as the blue rights, which provide a shield for individuals uh, to protect themselves against the state authority. So these rights guarantee the freedom from unlawful interference by the state. So these would be the rights that protect us as citizens or as people from the state so that the state does not abuse its power. These rights will include your political rights, which you can find in Section 19 of the Constitution, right to life, which is Section 11, freedom of speech, 15, freedom of association, which is 18, and so on. So these are the first generation rights. They protect you and me against the state, and they're also referred to as blue rights. Okay, on the second one, which is the second generation rights, which are also referred to as the socio-economic rights or the red rights. These are the rights that they don't give you a shield like the first one. These ones, they give you a sword against the state, which gives you, as a citizen, the right to reasonable housing, medical service, education, and work. These rights were also emphasized after the Industrial Revolution and socialist. So when we're talking about the right to housing, you're looking at Section 26 of the Constitution, and then the right to health care, which is Section 27. That would be the right to health care, food, water, and social security. And then if you're looking at the right to education, also listed there is Section 29 of the Constitution. So these are the second generation rights, also known as the socio-economic rights or the red rights. Okay, so the last one that we're going to refer to now, it is the third generation rights that have been identified more recently. So these are the rights which in general pertain to groups. They include the right to a healthy living environment and the rights to development and self-determination. These rights are also referred to as the green rights. So these would be your newer rights, the rights that have been identified recently. Okay, the limitation of rights, very interesting subject I like to talk about. When we talk about the limitation of rights, the first thing that needs to come to mind is Section 36 of the Constitution, which is also referred to as the limitation clause. So a perfect example that you can use uh, if or when a question comes with regards to the limitation of rights would be, for example, the time that we had COVID, our freedom of movement was restricted. So when does this limitation apply and how does it apply? It must apply as a form of law, which is generally applicable. So it has to be applicable to everyone. It cannot be directed to one specific person, but it must be directed um, to everyone. So we had our freedom of movement limited. We couldn't go to other provinces. We couldn't leave the country. And most importantly, we could not leave our homes. So that also shows that all the rights that you see in the Constitution or in the Bill of Rights, they're not absolute and they can be limited. And also the example that was used in your textbook is the example of the freedom of speech, that where you have your own publication, and that publication is designed to critique the government on how the government operates. The government now can't come and confiscate your stuff because you're critiquing them, right? But that right is also, it can also be limited in terms of the law of general application. So we have used an example in the cases of the state of emergency, and you must know Section 36 of the Constitution, which tells you that um, the rights in the Bill of Rights may be limited only in terms of the law of general application, but there are certain factors that need to be taken into consideration before you limit any rights. First of all, you have to look at the nature of the right. You have to look at the importance of the purpose of the limitation. You have to look at the nature and the extent of the limitation. Number four, it will be the relation between the limitation and its purpose. And number five would be a less restrictive means to achieve the purpose. Have they looked at a less restrictive means to achieve that particular purpose? So if you check all these factors and then you check all the scenarios and the cases that we went through COVID, you will see that the nature of the rights that were limited was, for example, your freedom of movement. Look at COVID-19, how it was transmitted. So if people had to move around, then we wouldn't stop the spread of the virus. That was the nature of the right. And then the importance of the purpose for the limitation. And then you look at the purpose here is to save lives. What does it link to? It links to the right to life. And then number three, it is the nature and the extent of the limitation, the nature and the extent of the limitation. You will see the extent of the limitation. We were not allowed to move at certain times, but because as humans, we need to be able to move. So there was an extent to the limitation where they gave us maybe an hour per day to walk or something like that. That refers to the nature and the extent of the limitation. It shouldn't be as extreme. It should be proportionate to the emergency at hand. And then the relation between the limitation um, and its purpose, that would be, for example, obviously when they limit you for movement, there needs to be a link between the public movement and the virus, which was COVID-19 at that time. So there has to be a link between the two. They can't say now, um, for example, the grapes had nothing to do with COVID, and then they're like, uh, okay, there's COVID-19, therefore don't eat grapes. So there is no link between COVID-19 and the grapes. But you will see that, for example, another perfect example, I'm not sure if this was verified, but it was the sale of tobacco or the sale of alcohol. Let's use the example of the sale of alcohol, for example. The relationship between the sale of alcohol and COVID-19. It was not directly linked that the sale of alcohol spreads COVID-19, but the logic was behind the sale of alcohol. And in most cases where people drink alcohol, they gather at a certain place. So that will lead to further transmission of COVID-19. So there was a relationship between the limitation and its purpose, which was to save life, and COVID-19, right? And then the last one would be, have they looked at the less restrictive means to achieve the purpose? So you'd look at things like, what did the government do to achieve a less restrictive purpose? Like, for example, to say, okay, fine, schools are not going to shut down completely, but everything will be done online. That's less restrictive because you can still get access to school. So I remember Section 36, the rights in the Bill of Rights may be limited only in terms of the law of general application. And remember the factors, and then you can have your example for COVID-19 or any other related example thereof. Okay, so the next point or the next talking point will be on the legal subjects and their capacities. Okay, so let's start with regards to the legal subjects. So when it comes to legal subjects, we have natural persons, and then we have juristic persons. So when we're talking of a natural person, we're talking of a human being, that is me and you. And then when we're talking of a juristic person, we're talking of an association of people, such as a company, a university, a bank, a political party, or a trade union. So these would be the two types of persons. We have a natural person and we have a juristic person. Natural person is human beings. A juristic person is your company, universities, bank, or political parties. Okay, so now let's talk about the capacities. Okay, so legal capacity is the capacity to be the bearer of rights and duties. In other words, um, to be a legal subject. So when you are a legal subject, you are the bearer of rights and duties. And another term for legal capacity is legal subjectivity. It's because these terms can be used interchangeably, right? So we have different types of capacities. The first one that we're going to talk about is the capacity to act. The capacity to act is also known as the capacity to perform the juristic acts. And a juristic act is a lawful act to which the law attaches at least some of the consequences as envisaged by the acting parties, right? So that capacity to act can apply to certain people or to certain persons, right? So when we look at the children that are under the age of 7, they do not have a capacity to act. We refer to these children as infants. They don't have any um, capacity to act, so they cannot perform any juristic acts. That also includes people with psychosocial disabilities. They also have no capacity to act. They can perform no juristic acts and cannot, for example, enter into contracts or anything, right? And then we have the limited capacity to act. For that, we'll be looking at the minors between the ages of 7 and 18. They can perform certain juristic acts, but they would need to obtain permission from their parents or their guidance. So they need to be assisted, right? So for example, let's say a minor wants to get married. Obviously, they must need permission, but with the regards to marriage, there's certain terms. There's a certain age that a minor has to be as guided by the Children's Act or family law. So minors between the ages of 7 and 18 can perform the juristic act, but they need permission from their parents or guardians. They need to be assisted, right? And then we have the full capacity to act. So this is me and you, people who have the capacity to perform all the juristic acts themselves, whereby we don't need assistance. These are the people that are over the age of 18 and don't suffer from any psychological disabilities or mental incapacity, right? So we have three forms. We have children under the age of 7 with no capacity at all. And then we have minors between the ages of 7 and 18 who have limited capacity to act. And then we have adults that are 18 years and over without any psychosocial disabilities that have the full capacity to act. Just as an extension, we will also talk about the capacity to take part in legal proceedings. So this is the capacity to appear in court, also referred to as loci standard. So in other words, for a party to be able to take part in civil proceedings or in criminal proceedings, they need to have the capacity to do that. For example, a child between the ages of 0 to 7, which is an infant, they cannot be a party to court proceedings. A parent or a guardian, they have to be there as a representative to assist them, right? And then, not to assist them, sorry, but to appear on behalf of them. And minors can usually appear in court with the assistance of their parents or guardians. But as for infants, they cannot be a party to court proceedings, right? They need their parents or their guardians to be their representatives. Okay, let's talk about alternative dispute resolution. So the whole purpose of ADR is that sometimes you have people that live like very far away in the remote areas where there are no courts, or where there are courts, but the courts are very far. And also we must know that litigation is very, very expensive. And in most cases, cases taken up for litigation, sometimes they take very, very long before the matters are resolved. Therefore, we have alternative dispute resolution. So we'll look at 3 types of ADRs, which is the first one will be like your negotiation. Let's say your neighbor plays very loud music at night and they're keeping you awake. So negotiation does not involve lawyers. It does not involve any experts. It's just you walking up to your neighbor and telling them about the problems that you're having, and then you can just negotiate and find common ground without taking the matter further. So that will be negotiation. We don't need the involvement of the court, the negotiation. And then the second one would be mediation. Mediation also takes place in cases where there is a conflict between the parties. Therefore, a mediator is appointed, or the conflicting parties ask for a third party, which we refer to as a mediator, to assist them in finding a solution through discussions and negotiations. So usually the mediator communicates with the parties individually, and then the information given by one party to the mediator is usually confidential and is not communicated to the other party. However, the mediator is usually a go-between, and he assists the parties to consider all possible solutions. In that way, the parties themselves, they find a solution, and then through those negotiations and mediation, and then both parties win. Okay, so that will be your mediation. You look for a third party who's going to sit impartial, listen to both sides of the stories, and then the solution will obviously come from both parties. It's also a way of finding common ground. And the last one would be arbitration. So in cases of arbitration, we have the 2 parties that conclude a contract in which they agree to appoint a third person. That person is referred to as the arbitrator to resolve their dispute. So the parties, we have the 2 parties here, and they're having a problem, and then they decide, okay, cool, we're going to conclude a contract in which we agree that we're going to appoint a third person, in this case, that is the arbitrator, to come and help solve this problem. So usually an arbitrator is an aspect in that particular field, and then he will come down and speak to the parties, and then he will hand down a decision. And then after the decision, the parties can agree that the details of the process, that they are happy with them. And then they may also take that decision and take it to court and have it made a court order. And then it will be binding to both parties. So that's arbitration. So we have negotiation, mediation, and arbitration.